Picture this. You're in a job interview. Everything is flowing well. The hiring manager is warm, engaged, clearly interested in you. Then she leans forward and says, "So, are you planning on starting a family anytime soon? Because this role does require quite a bit of travel." You pause. You don't want to seem difficult. You don't want to derail what feels like a promising conversation. So you answer. You explain your situation, you move on. Or picture this. You've been at your job for 2 years. End of a long shift. Your manager catches you on the way out and says, "Hey, before you clock out, can you just stay and finish setting up the floor? It won't take long." You stay. Because that's what you do. Because saying no feels like the wrong move. Here's what you didn't know in either of those moments. In the first scenario, that question was illegal. Full stop. Your employer had no legal right to ask it. In the second, the time you worked after clocking out is compensable. You were legally entitled to be paid for every minute of it. These are not edge cases. These situations happen every single day across every industry in this country. And the reason employers keep doing it is straightforward. Most workers don't know it's illegal. And what you don't know, you can't push back on. Today, we're changing that. What's up, everyone? It's Soluna. Welcome back to Soluna versus the System, the channel where we break down the rights you already have that nobody told you about, so you can stop being taken advantage of at work without even realizing it's happening. Today, we're covering 5 illegal questions and requests your boss might make, what the law actually says about each one, why these violations are far more common than most people realize, and exactly what to do when it happens to you. Quick disclaimer, nothing in this video is legal advice. This is education only. If you're dealing with a specific situation at work, please consult an employment attorney in your state. Let's get into every single one. Illegal question number 1. Questions about your age. Your employer can legally ask whether you're over 18 or over 21 if the job involves serving alcohol. That is the extent of what they are entitled to know about your age. Anything beyond that starts entering legally problematic territory. What they cannot do is ask for your specific age, make comments designed to figure out whether you're too old for a role, or pressure you in any way around retirement. Phrases like, "We're looking for someone with more youthful energy," or "Are you sure you can keep up with the younger team members?" are not casual observations. They are potential evidence of age discrimination. Why does this matter? Because the Age Discrimination in Employment Act, a federal law covering all 50 states, protects workers who are 40 and older from age-based discrimination in hiring, firing, pay, and promotions. Most states have additional protections layered on top of that. This doesn't only show up in interviews, it shows up in performance reviews, in conversations about your long-term future at the company, in subtle comments about retirement. If you're receiving persistent questions about your age that have no clear connection to your ability to perform the actual job requirements, that is a legal red flag. What to do? Redirect professionally. I'm focused on my qualifications for this role. Happy to discuss those. Document the comment, and know that you were never required to answer. Illegal question number 2. Questions about your family. Are you planning to start a family soon? How are you going to manage childcare with these hours? Do you have a spouse? Kids at home? All of those questions are off limits. Your employer has no legal right to ask whether you're married, whether you have children, or whether you plan to have them. These questions are rooted in outdated and discriminatory assumptions about commitment and availability, and they fall disproportionately on women. Title VII of the Civil Rights Act prohibits discrimination based on sex, and that protection explicitly includes pregnancy and familial status. If your employer is asking about your family situation or making assumptions about your dedication because you have children, that is textbook discrimination under federal law. The only thing your employer is entitled to know is whether you can perform the essential functions of the job. Your family situation is entirely irrelevant to that question. The moment they treat it as relevant, they have a legal problem. Illegal question number 3. Questions about your medical history. Before a job offer is made, employers are broadly prohibited from asking about disabilities, medical conditions, or health history. Questions like, do you have any health conditions we should know about? Or, have you ever filed a workers' compensation claim during an interview are completely off limits under federal law. The nuance here is important. After a conditional job offer is made, employers can ask medically relevant questions, but only if they ask every candidate for that role the same questions, and if you request a reasonable accommodation for a disability, a focused conversation about your specific functional limitations is appropriate and legally protected. But that is a specific, employee-initiated conversation with defined boundaries. It is not a general fishing expedition into your health history. The Americans with Disabilities Act protects workers from discrimination based on disability. An employer can ask whether you can perform the essential functions of the job with or without reasonable accommodation. They cannot dig through your medical history to inform a hiring or employment decision. If you're receiving health-related questions before a job offer, especially questions that have nothing to do with the specific requirements of the role, that is a serious warning sign. Illegal question number 4. Questions about your religion. Your religious beliefs are yours. Your employer has no legal right to ask what religion you practice, how often you attend services, or which religious holidays you observe, unless you have specifically initiated a religious accommodation. If you need a particular day off for a religious observance or need a schedule adjustment to attend services, you can bring that up as an accommodation request. At that point, your employer can engage in that conversation. That is the appropriate and protected channel. What is not appropriate is your employer proactively asking about your beliefs to inform employment decisions. Comments about your religion, pressure to participate or not participate in religious activities, or a work environment made hostile because of faith are all violations of Title VII of the Civil Rights Act. If your boss is bringing your religion into workplace conversations that you didn't initiate, that line has been crossed. Illegal request number 5. Working off the clock or waiving overtime. This is the most common violation on this entire list, and it is almost always disguised as team spirit or a casual favor. Just clock out and finish those files real quick. We all just pitch in, stay a little late off the clock. Can you finish the report at home tonight? It won't take long. If you are an hourly, non-exempt employee, the Fair Labor Standards Act requires that you be paid for every minute you work. If your employer knows, or reasonably should know, that you are working, they are legally required to pay you for that time. No exceptions, no workarounds. This applies to working before your shift to set up, working through an unpaid lunch break while answering calls or completing tasks, and finishing work at home after clocking out. All of it is compensable work time. All of it must be paid. And overtime? Non-exempt employees are legally entitled to overtime pay for every hour worked beyond 40 in a single work week. Employers who try to avoid this by misclassifying employees as exempt, by averaging hours across 2 weeks, or by simply refusing to pay overtime are breaking federal law. You cannot legally waive your right to be paid for time worked. Your employer cannot ask you to. If they are, that is wage theft. It has a specific legal name, and it is actionable. What to do? Keep your own time records independently of your employer's system. Save any messages where you were asked to work without pay. That documentation is your protection if this ever goes further. Here are the 5 things your employer cannot legally ask or require. 1.
your specific age, or anything designed to gauge whether you're too old or too young. 2. Questions about your family, marital status, or plans for children. 3. Questions about your medical history or disabilities before a job offer. 4. Questions about your religion outside of an accommodation you initiated. 5. Working off the clock or waiving your right to overtime pay. And the rule that applies across every single one of these: document everything. Write down what was said, when, and who was present. Save relevant emails or messages. Keep your own records of hours worked. Because if you ever decide to take action, legally or otherwise, that documentation is the difference between a strong case and your word against theirs. The system counts on you not knowing these rights. Today, you do. If this video helped you, smash that like button and subscribe. We drop new content every single week on exactly this. And drop a comment below. Has a boss ever asked you something that felt wrong? Tell me what happened. I read every single one. See you in the next one.